Sorry, that's me.
Test. Test. Unmute yourself. This is weird. I have a little bug here. Not letting me unmute you. All right. We are so thankful that you have chosen to participate today, and we look forward to having a conversation about accepting checks from your customers and other forms of payment, and just hopefully giving you some tips and ideas that help you in that. So if you have any questions today, as normal, you can submit those one of two ways. Sorry about that. You can submit the questions by either using your control panel, the GoToWebinar control panel on your screen, or you can use your email and send that to webinar@vannattorneys.com, and we'll be glad to answer those throughout the webinar. So again, we hope you will have a question and send those to us so we can answer that. Also, I was going to tell you, our next webinar is going to be August 22nd, 2019 at 3 o'clock. And our topic that we think we're going to be using is going to be on contract law, and that is which terms apply. Does your contract, does a quote, does a purchase order, confirmation of the order, which terms really apply, and why would that change? If you have a topic that you want us to use, I beg you to send it to me, to James Vann, or you can send it to webinar@vannattorneys.com. That helps us because we know what issues you're dealing with. We obviously hear from y'all a lot throughout the month, and we want to try to pick stuff and topics that are helpful to you. So we hope you will join us on August 22nd. So today we're going to talk about accepting payments and other forms of payment from your customers. And we know that you get a lot of different types of payments coming in, a lot more so today than maybe 10 or 15 years ago. Obviously, accepting payments from customers is what we're going to be talking about. How do you recover if the payment does not clear? And then the benefits, risk, and liability of accepting various forms of payment. So let's just go ahead and get started. So if your customer issues a check for payment and it doesn't clear, what are your options? What do you do? Many of you know you've got really two different options. One is a civil action, where you could pursue them civilly for the check and anything else they owe to you, to your company. It's generally the face value of the check. You can, in North Carolina, assess a processing fee that by statute cannot exceed $25. And that's not the bank fee, that's the processing fee that your company charges for the bad check. It's basically an administrative cost that your company can recoup. So again, you need to say that needs to be part of your process or your policy to say the processing fee and to give what that is. And again, $25 is the largest amount in North Carolina that you can assess. Whatever the bank service fee is, if your bank charges you for the bad check, you can charge that back to the customer as well. And in North Carolina, this has changed a little bit over since I started practicing. But we actually used to get treble damages for the check. So, for example, if the check were $5,000, it bounced. We filed suit on the bad check. We actually could get a $15,000 judgment plus all the other charges and stuff, which is really awesome. Unfortunately, the General Assembly changed the statute maybe, I don't know, 15 years ago, 12, 15 years ago. And you have to jump through several hoops now, and the treble damages can be anywhere from $100 up to $500. It cannot exceed $500. So in reality, it's not really treble damages. But if your check is a smaller dollar figure, then you can treble that. But again, the damages cannot exceed $500. So here's what and there's a process to do that. You've got to send 2 different letters, and the statute is really clear as to what the letter should say, what it should include in the letters. And in essence, you've got to wait 60 days, 30 days for each of the letters when you send that to the debtor before you can file suit to ask for the additional dollars on the treble portion. So in reality, for what many of our customers, because it's thousands of dollars or close to a couple $1,000 maybe, depending on obviously the debtor and the check. If the dollar amount is more, we really don't want to wait 60 days to get anywhere from $100 to $500. So sometimes they sort of took the benefit out of it unless it's a smaller dollar figure. There's also criminal an element to that for knowingly issuing a worthless check. And the statute uses the words knowingly issues a worthless check. There has to be insufficient funds and or the account being closed. And so how do you prove knowingly issuing a worthless check? Basically, let's say, for example, that, if they made an error and they said, oops, we made an error in our reconciliation of the bank statement and we just didn't know it. That probably would not satisfy, they would not be found guilty of a criminal offense. If they issued a check and they obviously knew they didn't have the money in there, or they're bouncing checks right and left, then more than likely they're going to be found guilty for that. In North Carolina, if the check is more than $2,000, that's a Class 1 felony. And there's also some other elements to it that you could get. If it's under $2,000, it can become a felony if they're habitual check writer, bad check writers, and so forth. So if you accept payments from a customer and you want to pursue them criminally, you can. Thankfully, you don't have to do anything in the sense of prosecuting other than going to the magistrate to get them to issue the warrant. You'll have to be involved with the evidentiary portion and ultimately in essence, the trial to probably testify, yes, you received the check and so forth, it bounced. But other than that, they do it for you. For the sentencing portion, it really depends on the criminal that's involved in the matter and what their criminal record is. The Class 1 felony, if it's over $2,000, if they're a first-time offender, then it's likely going to be a fine, a possible 4 to 6 month probation, and then restitution. That's really what you want, is the restitution. That's where the court says to the defendant, you have to pay this back, and in the following ways. And again, sometimes it's you need to pay this back now if they have the ability, or it may be you have to pay this back in 6 months or however, and it may be monthly payments. But again, the restitution, that really helps. If the defendant or debtor has a lengthy record, then it is possible they get prison time, a fine, and restitution. In reality, unless they are like a habitual bad check writer and everything else possible, a criminal record as long as you're armed kind of thing, most judges don't lock defendants up because of bad checks. And the reason being, there's just a lot more bad stuff going on. But that is a possibility. So again, it really depends on the judge and the circumstances. Again, I know your goal generally is not to have them locked up, because if they're locked up, they can't pay. So we don't really want to get them locked up. So accepting payments from the customer, a creditor can proceed with a civil action, that is suing them civilly, and a criminal action all at the same time. You can do both at the same time. However, you only can recover one time. So for example, if you start both processes, the criminal and the civil side, and let's say you recover, once you do that, and then the debtor comes to you and says, oh my goodness, I want to pay you so I don't have to deal with the criminal side. What I would encourage you to do is to, number one, negotiate, either you or your attorney, whoever is helping you, negotiate with the customer a way of getting certified funds, so that you know that you have actual good funds when they bring the money to you. And then after that, make sure you notify the district attorney. So they're probably going to drop the charges at that point. So you don't want to not notify the DA, because they're not going to take that very well. And the next time you get a bad check, they may remember that. So you want to make sure that you tell them what you're doing, what you're negotiating. So a lot of people call and ask us about accord and satisfaction. Some of you know what those terms mean, some of you may not. We'll explain it. But accord and satisfaction basically is when you receive payment from a debtor, from your customer, and they've argued, they're saying, I don't owe that much money, I'm just going to pay you what I think I owe you. And they try to get it, like payment in full, when it's not payment in full. That's sort of what accord and satisfaction is. So in North Carolina, accord and satisfaction is the cashing of a check or some kind of acceptance of a payment, and it can be cash. It doesn't have to be a check, but it can be cash as well, or credit card, in full payment of a disputed claim, and that equals accord and satisfaction. So again, it's got to be a disputed claim where the customer says, I don't owe you $10,000, I only owe you $7,000. They write you a check for $7,000. You go, no, it's $10,000. But I'm going to accept your check for $7,000 as payment in full. Then that's an accord and satisfaction. So hopefully that helps you understand that a little bit better. So an accord is the agreement where one party says, I'll pay you something or do something for you. The other party says, okay, I'll accept that in satisfaction of that disputed claim. Something different from what they're initially agreed to. And then the satisfaction is the actual execution or the performance, the carrying out of that agreement. So again, the customer comes to you and says, look, I don't owe you $10,000. I feel like I owe you $7,000 because of whatever. They dispute it. You say, okay, we'll accept the $7,000. That's the accord. When they write you a check or they pay you the $7,000, you acceptance, that's the satisfaction. So hopefully that helps you understand that. So the elements in North Carolina, I'll give you an example. There must be a dispute, right? So for example, here we got Andy claims that Bill owes Andy $20. Bill says, nope, I deny owing you any money at all, Andy. And then there must be an agreement where Bill offers to pay Andy $10 to settle. Andy accepts the money and considers it over. That's an accord and satisfaction. Another example, Andy sends Bill an invoice for $20. Bill sends a $10 check marked paid in full. In this example here, there's no accord and satisfaction because there's no evidence or allegation of the dispute over the account. Andy just sends a $20 invoice. Bill just sends a $10 check to him. Bill didn't say, hey, I don't owe you this, I don't owe you the 20, or there was a problem with some of the product or services I received. So there's no evidence or allegation of a dispute. Even though he wrote paid in full, there's no evidence of that. Well, if there's no evidence or allegation of negotiation concerning the payment, then that's not going to count as an accord and satisfaction. The notation paid in full does not constitute that at all. I will just tell you this before we get any further. If you see that on a check and that's not paid in full, I would just tell you, don't buy a fight. At that point, I would encourage you to write by email, or you can call your customer and say, hey, look, I just got your check for this amount. This is not paid in full. We will not accept that as payment in full. We will accept it towards payment of the account, but not in full. If they agree to that, then I'd send an email to say, hey, just spoke to you on such and such date, explain this. This is not paid in full. Even though you wrote that, you agree this is not paid in full. We're going to deposit the check. If you disagree with that, you need to notify me in writing within 24 hours, and then deposit the check after the 24 hours. Just don't unwillingly buy yourself a fight, you know. So, all right, another example. Andy and Bill enter into a contract for Andy to paint Bill's house for $20. Andy finished the job, paint looks wonderful, invoice Bill for the $20. Bill told Andy that the invoice was too high, didn't like the final product, it's just too high, right? So Bill pays Andy $17 and then marked the check paid in full. Andy cashes the check. In this case, that does constitute accord and satisfaction, because Bill said, hey, look, this is too high. Even though he initially agreed to pay $20, he later says, I'm only going to pay you $17. In that case, that's an accord and satisfaction. Again, you just don't want to buy into a fight if you can help it. So in this example, there was a dispute. Bill told Andy the invoice is too high. The existence of the dispute, along with the notation of paid in full, established that there was an accord and satisfaction. So in that case, you got to be thinking about that a little bit. So also in North Carolina, there's, you know, the Uniform Commercial Code. Most states have adopted this. I know some of you are in states other than North Carolina that this would apply as well. If your state has adopted this portion of the UCC, and they've adopted and codified the accord and satisfaction, they're saying that if there's a payment as full satisfaction and the amount of the claim is disputed and the claimant obtained payment, then that would be accord and satisfaction. So hopefully that helps. I'm not going to beat that horse a whole lot more. I do want to mention to you one thing though. If there's the claimant is an organization, and within a reasonable time before the payment was made, the claimant sent a statement to the person against whom the claim is asserted, saying in essence that they're disputing the debt, and they include a check or some form of payment as full satisfaction, and they send it to the person they're talking to, that's one thing. If they send it to another office, say another branch, or even a lock box, if you're using a lock box, then that is not accord satisfaction. But again, I want to get you mindful of, don't buy a fight. If someone owes you $20,000, they send you a check for $15,000 and they say paid in full, even though they've not ever said anything else about, hey, look, you know, I dispute the charges or whatever. Don't accept it until you've sent them an email or a call and then an email, so that you have a great record trail of what you're doing and why. It just gives you a lot of protection. So if the claimant knew that the payment was made in satisfaction of the claim, then that you might be in a different circumstance in that case. So when you're accepting the payments, just think through this way. And I know y'all get hundreds and hundreds of payments in a month. You know, is there a dispute? Has someone in some way claimed a dispute? Is there a pending lawsuit? If there's a pending lawsuit, that obviously would be a dispute. Is there a notation on the check? Is there correspondence that came with the check? And obviously, if it is, then you need to look at that before you deposit it. And then what discussions have occurred between you and the debtor? Or obviously, if the debtor, your customer, has spoken maybe to the sales staff and they've not shared that with you yet, then that's another circumstance. Again, if you see something that's payment in full or some similar notation, then you need to really slow down and think through that just a touch. And I hope that helps. So, a few tips for you on accord and satisfaction. If the payment has a notation of payment in full or something of that nature, then slow down. Write the customer in writing, put it in writing, and an email works if you've got a good email address. State that it's not payment in full. Ask for a reply within, say, 24 hours, and if not, then you're going to cash the check. But you got to make sure that you got a good email address, and that's why I would say talk to them ahead of time, because then you can say in the email, this is to confirm our telephone conversation on such and such date and time, wherein I said this and you said this, and we're going to deposit the check unless you tell us otherwise, but it's not payment in full. If they say, no, it's payment in full, then I would tell you, don't deposit the check, because then that's a disputed claim, and you don't want to get into an accord and satisfaction if it's not. So we've got a questionnaire we'd love to have you answer for us. So that should be popping up on your screen in just a few minutes. And this is just something that hopefully is helpful to you. So the question is, does your business have more returned checks or more credit card chargebacks? So if you would just answer that for us. So do you have more return checks or credit card chargebacks? So y'all are doing an awesome job of voting. We're almost up at 75, 78, 80%. So we'll give you about another 10 seconds here. So again, and we're going to talk about credit card chargebacks and why that happens and what you can do ahead of time to prevent that, hopefully. And when it does happen, then what do you do? So, okay, we're going to show you the results here. So does your business have more return checks or credit card chargebacks? 80% return checks, 20% chargebacks. That's interesting. So obviously this is hopefully a less of a problem than it used to be maybe 10 years ago, but credit card charges still are something that's 20%. So 80-20, that's interesting. Okay, thank you for doing that. Okay, so how do you recover if the payment does not clear? What do you do? Well, it depends on obviously what kind of payment you received. In North Carolina, you can of course file suit. In North Carolina, the small claims dollar amount is $10,000. It can exceed $10,000. So let's say that they wrote a check for 10 grand and it bounced, and they owe you the 10 grand plus some other stuff on their account. You cannot sue them for 10,000 plus the other stuff. Now you can do a small claims on the $10,000 bad check, but then you have to sue them for the rest of the stuff from the open account. You can of course hire an attorney to help you that also can include amounts due, but were not included in the bad check. So if you're going to sue them, you can sue them obviously for the bad check plus the other stuff that they owe, other amounts that they owe you. So you can certainly do that. You can do a criminal action, and you can do both, as we talked about just a little bit ago. So let's look at the various forms of payment. Today, there are so many more forms of payment that I feel like are prevalent. Obviously, check and cash are pretty popular. Credit card, there's wire transfers, and also, and I know this is probably gaining in popularity because some of you who I know are on the call or on the webinar today have started accepting online bill payments. Some of you are doing a gateway and a shopping cart. Again, I know your business, it depends on what your business is and how you communicate with your customers, but that's going to become a lot more popular down the road. Mobile payments are gaining in popularity, where you swipe or either have a keypad entry. And then, of course, there's a recurring billing where if you just say, for example, you're selling to your customer X number of products every month, and that's what you bill them and they pay you. It's just automatic. I don't know how many of y'all are doing wire transfers, but I'll tell you, wire transfers are really, really good. And I'll tell you why. It's immediate. You don't have to worry about it clearing. Once the wire transfer is made, it'll take about 12 hours, 6 to 12 hours for it to settle. And that's the bank's terminology. And I think what that means is the money's already transferred, but it's just got to somewhat resolve itself between the two banks. But wire transfers, once it's confirmed, cannot be taken back. They cannot dispute it later and get the money back. It's done. It's gone. Of course, Bitcoin is an option. We didn't mention that's what the picture is. If any of y'all are accepting Bitcoin, I'd like to know about it because I'd like to talk to y'all more. Probably not something that you're necessarily accepting, but it may be down the road. We don't know. Be something interesting. So how do you, what about valid disputes to a credit card? Someone else, these are valid excuses, right, or valid defenses, I should say, for your customer. Someone else used their credit card without permission. So if someone got your customer's credit card and purchased stuff and used their credit card, the customer could say, "Hey, look, it's fraudulent. I didn't do it. Someone else did it." If there's a billing error on the creditor's part, right, that would be a problem. That would be a valid dispute. Or if there's good faith effort to resolve with the creditor. Those are the ones that the credit card companies look to as being valid disputes. And then we actually had a client not too long, well, several years ago, who made a purchase of a product. He was a consumer, but made a purchase of a product and paid with a credit card, and the product there was fraud involved in the purchase of the product on behalf of the seller. Our client was on the hook with a credit card company for a lot of money. I mean, it was a lot of money. And we were trying to fight with the fraudulent seller and buy time, if you will, with the credit card company. We bought about a year and a half, but unfortunately, the fraudulent seller they were very slippery, and the entity basically was worthless. And it was a bad deal. But the reason I tell you that story is this: we disputed the charges based off the fraudulent activities of the seller, and the credit card company allowed us to do that for about a year and a half. We kept them apprised of what was going on, but ultimately we had to pay them, or our client did, and he had to work it out with the fraudulent company in a different manner, but he eventually had to pay the credit card company. But thankfully, the credit card company helped him in that case because of the fraudulent activities. So how do you defend on a credit card dispute? Well, here's what all the credit card companies are telling you. Here's what the contracts say generally is gather the facts. You, as a creditor, you need to gather the facts. Look for signed receipts, look for delivery or pickup documents. Hopefully someone if you're all accepting credit cards, has information about the customer's IP address. If there are any digital documents involved, gain as much documentation as you can so that you can send that to the credit card vendor. And then you need to file a counterclaim to prove that the customer approved the charge. And in these cases, the time limits that are imposed by the credit card companies are generally pretty short. You may have anywhere from 10 to 15 days. You may have 30 days, but more than likely it's going to be 10 to 15 days that you have to respond on the chargeback. So again, please be really diligent. I don't know if that's your bailiwick that you got to take care of, or if that's someone else that deals with the credit card companies, but you really need to be looking at that and respond quickly. So the benefits and risks of accepting checks. Obviously, the benefits, it's very common today. Whether or not that's going to become less so going forward, I don't know. I don't know if you've got an idea, but certainly that's the benefits. It's easily used. It's something that's been around for a long time. The drawback is you may have people that write bad checks, right? That's probably the biggest risk. And the float time from the time they mail it, the time you get it, deposit it, and then whether or not you find out, how long it takes you to find out that there was a fraudulent check or insufficient funds. Credit card payments, well, same thing. It's fast. There is probably a higher cost of carrying the credit cards as far as just the fees that go involved with them. Also, the liability side of it, or the cost factor is that someone could dispute the charges, and then you're back on your defensive side of showing why it's not, why it should be paid and it's not a valid dispute. The wire transfer, the benefits, it's fast, it's good money really quickly, and generally speaking, once it hits your account, it can't be taken out. The bad side of this is if you give the wrong information on your wire transfer and they put it in someone else's account, it's pretty much gone. You might be able to get it back if you do act quickly, but you've got to make daggum sure you got all the right information for the wire transfer. Every number counts, and you got to make sure you get it right. So some tips here to avoid the credit card chargeback. Follow the processor's protocol. Whatever they have in writing, you really got to do. Have a good written contract with your customer if you're accepting payments. by credit cards. You got to promptly respond. You make sure you train everybody who's involved in those types of transactions, and keep really good records. Thankfully, so much of this is electronic now. If you're accepting more credit card payments, I would highly encourage you to, in that process, come up with ways, and it involves your IT staff, so that you know those documents are being captured electronically, and that's not a problem. So, if you've got questions, we'd love to hear from you. But we've got a question here. It says, if we file a criminal charge for a bad check over $30,000, and the customer comes in after it is filed and pays for the check, we cannot. Since we cancel the charges. I apologize. I'm trying to read this small screen. Does the felony charge stay on his record after we cancel it? Great question. So $30,000 check, charge them criminally, but if it's before they're actually found guilty, then more than likely, no, it won't be on their record. The fact that they were charged might be on their record, but there won't be a guilty. It would say dismissed. There won't be a fact of them being found guilty. If they are found guilty by the court and then they pay it, then yes, it's going to be on their record for probably 7 to 10 years. But again, the charge would still be on there even if they paid it before the criminal court agreed to it. And then the other question is, does this info only apply to COD accounts or payments on charge accounts? These, as far as I'm going to make sure I got the question. Was that only for, does this apply only to COD accounts or payments on charge accounts? What we've been talking about applies, it doesn't matter if it's a COD, a credit account, or one time, it doesn't matter. So what we've talked about really involves, no matter how the debt arose, if it's a debt from a chargeback or from a credit card or from a check payment, it doesn't matter if it's on an open account or if it's COD. So hopefully that helps. Really do hope y'all have this has been beneficial for you. And if you've got questions, please feel free to send those to us. You can email me directly, or you can send it to our firm. We'll get back with you. And again, we would really love to hear from you. If you haven't linked with us on our website or on the social media stuff, and you're involved in social media, we really would love for you to do that. It's a great way that we try to send out information that way, and we really want to make sure we're a service provider for you. Thank you so much. We do hope you will participate with us on August 22nd. We hope you have a great afternoon. Thank you.